Newly exposed evidence is turning the Karmelo Anthony case upside down, and there's now a real possibility he could get a retrial. In open court this week, shocking evidence about Austin Metcalf's documented history resurfaced. Racist graffiti, school discipline, past bullying accusations, the kind of record that never made it in front of the jury that convicted his killer.
CBS News Texas has also learned new details about Austin Metcalf's background. Metcalf and his brother Hunter were once caught spray painting graffiti, including KKK Kill All Blacks and Heil Hitler, along with the N-word, and were sentenced to 12 months of juvenile probation. Records reveal they reportedly told authorities, "We did some dumb stuff. We did some vandalism." There are several documented instances of Austin using racial slurs in school.
Karmelo Anthony was sentenced to 35 years for stabbing Metcalf to death at a high school track meet. Case closed, or so it looked. And now, here's where the twist comes in. During the same hearing, prosecutors revealed alarming messages found on Anthony's own phone. A text sent hours before the stabbing in which he allegedly fantasized about stabbing someone and licking the blood off the blade. Both sides, it turns out, had quietly agreed to keep all of it. His messages, Metcalf's record, buried from that jury. Now a new judge has until Monday to decide whether that secret is enough to undo a murder conviction, and whether Karmelo Anthony walks back into a courtroom or spends the next 3.5 decades in a Texas prison cell. This is the kind of case that makes you ask what a fair trial actually means when the people running it decide, on their own, what you get to know. Which is exactly the kind of question The Fatal Truth exists to dig into. So if you want the full, documented picture instead of the version that fits on a phone screen, subscribe and stay with this investigation. To understand what's happening in that courtroom right now, you have to go back to a Wednesday morning in April of 2025 at a high school track meet that had no business making national news. Memorial High School and Centennial High School, both in Frisco, Texas, both part of the same district, were competing at David Kuykendall Stadium. It was 10 in the morning, parents in the stands, athletes warming up, the ordinary noise of a school sports event. Austin Metcalf was 17, a Memorial High School student and athlete, a twin. His brother Hunter competed at the same school. Karmelo Anthony was also 17, a student at Centennial. The two boys did not know each other well. What's documented is this. Anthony was sitting under a tent that belonged to Metcalf's team. Metcalf told him to leave. Words were exchanged. Metcalf grabbed or shoved Anthony. Witnesses and a blurry piece of surveillance video would later back that part up. And in the seconds after that shove, Anthony pulled a knife from his backpack and stabbed Metcalf once, in the chest. Metcalf died at the scene. Anthony turned himself in to authorities shortly after. He was charged with first-degree murder. He has always maintained it was self-defense. That's the official, undisputed skeleton of the case. A fight over a seat under a tent that ended with a 17-year-old dead and another 17-year-old facing life-changing charges. Frisco police responded within minutes of the stabbing, and the investigation that followed leaned heavily on two things: the knife itself, recovered at the scene, and a piece of surveillance footage from the stadium that captured the shove and the seconds immediately after it, though not a clean, close-up view of the stabbing itself. Investigators also collected witness statements from athletes and coaches under and around the tent, statements that would later become the backbone of competing timelines at trial. One side describing an unprovoked physical attack on Anthony, the other describing a minor physical removal that escalated into deadly force. A grand jury indicted Anthony on a charge of first-degree murder roughly a month after the killing, which meant prosecutors believed, even at that early stage, that the evidence supported an intentional killing rather than a justified use of force. That indictment set the terms for everything that followed. A self-defense case where the physical evidence was undisputed and the argument was entirely about what was reasonable in the seconds before the knife came out. What made it a national story wasn't just the stabbing. It was everything that got layered on top of it almost immediately. Anthony is black. Metcalf was white. Within days, the case was being discussed less like a specific criminal matter between two specific teenagers and more like a referendum on race, self-defense law, and who America decides to protect. Both the prosecution and the original defense would later tell the jury, on the record, that race had nothing to do with what happened under that tent. Online, that framing never stood a chance. Fundraisers went up for both families. Anthony was released on a $250,000 bond and moved with his family into a rented home in a gated community, a detail that, fairly or not, became its own controversy. Threats came in against both sides. By the time this case reached a jury, it was no longer just a criminal trial. It was a proxy war, and everyone involved, investigators, attorneys, the judge, was operating inside that pressure. That pressure didn't stay online either. Commentators and creators on both sides of the political spectrum built entire channels of content around this single stabbing, and a lot of it had nothing to do with evidence. Anthony was flattened into a symbol by some, celebrated by others, and turned into a punchline or a slur target by people who never sat in that courtroom and never read a single police report. Metcalf's family faced their own version of it. Grief mined for engagement. Their son's death, narrated by strangers who'd never met him. Some of it sympathetic, some of it dehumanizing in the other direction. Austin Metcalf's father gave interviews in the aftermath, talking about faith and forgiveness. He also, at points, sparred publicly and heatedly with online commentators and with figures connected to Anthony's side, which only fed the churn further. None of that noise is evidence. None of it belongs anywhere near a jury room. But it's the atmosphere every single decision in this case. The gentleman's agreement, the media restrictions, even Judge Roach's post-verdict interview was made inside of, and it's part of why the people running this trial kept choosing to close doors instead of opening them. Here's the first turning point most people never clocked at the time. Before a single juror was seated, prosecutors and Anthony's original defense attorney, Mike Howard, made a decision that would come back to blow up the entire case a year later. According to testimony later given in open court, both sides agreed, off the record, verbally, nothing in writing, to keep certain background information about both boys away from the jury entirely. Not because it was legally inadmissible, because they were afraid of what it would do to an already racially charged case if it got out. That agreement would stay hidden from the public for over a year, and it's the reason this story isn't over. The trial started June 1st, 2026, in front of Judge John Roach in Collin County, and almost immediately, the proceedings were unusually closed off for a case with this much public interest. No cameras, no audio recordings released to the public. Public seating was capped at 27 people in a courthouse fielding demand from across the country. A small handful of credentialed media outlets got a seat inside. Everyone else got secondhand reports. The defense argued self-defense, that Metcalf's shove was the aggressive act, and Anthony reacted to a perceived threat. The prosecution argued that pulling a concealed knife and stabbing someone once, fatally, in response to being shoved out of a tent, was not proportional, not defensive, and was murder. What the jury did not hear, from either side, was almost any character evidence about who these two boys actually were outside of those few seconds. No real testimony about Anthony's background, no real testimony about Metcalf's, just the tent, the shove, the knife. The jury that heard the case was seated after an unusually difficult selection process in a county where the case had already saturated local news for over a year, and, notably, it moved forward without a single black juror on the panel, a detail Anthony's new legal team would later point to as one more reason to question whether the trial gave him a fair shot. According to later reporting, the jury deliberated for a matter of hours, not days, before returning a guilty verdict. Karmelo Anthony was convicted of murder and sentenced to 35 years. For a case that had consumed the country's attention for over a year, the trial itself moved fast, ended fast, and, because of the restrictions on cameras, audio, and public seating, was witnessed directly by almost no one outside the room where it happened. The jury that decided Karmelo Anthony's fate did so with a file that had been deliberately narrowed before they ever walked into that room. What they didn't know is about to become the entire case. Days after sentencing, Judge Roach did something judges are generally trained not to do. He sat down for a television interview with a local station and talked about the case he'd just presided over. Asked whether the jury got it right, Roach said the jurors were picked based upon the law, that they listened to the facts, and that they got it right. Later in that same interview, describing the defendant, Roach said, "He seems like a nice young man who committed a crime." He also defended his own courtroom decisions, including the decision to bar cameras and cap public seating at 27 people. At the time, it read like a judge simply reflecting on a high-profile case that was finally behind him. It would turn out to be the single biggest mistake of the post-trial process, and the thread that, once pulled, unraveled almost everything else. Because within days of sentencing, Anthony's defense picture changed completely. Trial attorney Mike Howard, who had represented Anthony from arrest through verdict, stepped back, and a new legal team, a group of well-known civil rights and criminal defense attorneys, led by attorney Russell Wilson, stepped in to represent him pro bono for the appeal. Bringing in a fresh team for post-conviction work isn't unusual on its own. What made this notable was the profile of the attorneys involved and how quickly they went to work building a procedural attack on the trial itself, rather than simply re-arguing self-defense. And they moved fast. 2 motions were filed almost immediately, one asking to recuse Judge Roach from any further involvement in the case, and one asking for a new trial entirely, spanning 63 pages of allegations. A notice of appeal went in alongside them. The clock on all of this mattered. Under Texas law, a judge has 75 days from sentencing to rule on a motion for a new trial, and if no ruling comes down in that window, the motion is automatically denied. Anthony was sentenced June 9th. That put a hard deadline on the calendar, Monday, August 24th, 2026. Everything that's happened since has happened inside that shrinking window. The defense's very first move wasn't to argue the facts of the stabbing again. It was to go after the judge himself, and it worked far faster than almost anyone expected. On August 19th, a recusal hearing was held in front of a visiting administrative judge, Sid Harrell, brought in from San Antonio, a judge with his own history in high-profile cases, having previously presided over the trial connected to the Uvalde school shooting response. Anthony's defense played an 18-minute video built from Roach's post-verdict television interview, arguing that a sitting judge publicly praising a jury's verdict and offering his personal read on the defendant's character created, at minimum, the appearance of bias in any proceedings still ahead. Judge Harrell didn't rule based on whether he personally believed Roach could still be fair. He was explicit about that. He said the legal standard wasn't whether Roach himself could set his opinions aside. It was whether a reasonable member of the public could look at those comments and reasonably question his impartiality. By that standard, Harrell ruled, Roach had to go. Roach was recused from any further proceedings in the case. A retired judge, Michael Chitty of Kaufman County, a judge with nearly 2 decades on the bench before retiring, first appointed back in 2004, was brought out of retirement to take over. Legal analysts covering the case were careful to note that the recusal was a real win for Anthony's team, but not a guarantee of anything. It didn't erase the conviction. It didn't erase the sentence. It just meant somebody new would be the one deciding what happens next. That what happens next started the very next morning, August 20th, when Judge Chitty opened the hearing on the actual motion for a new trial. And this is where the case cracked open, in a way nobody outside the courtroom had seen coming. Assistant District Attorney Bill Wersky, the lead prosecutor from the original trial, stood up and for the first time publicly confirmed the existence of that pre-trial agreement, the gentleman's agreement, as attorneys on both sides kept calling it in testimony. He explained the reasoning bluntly. Both sides were worried that airing the full, messy backgrounds of both teenagers would turn an already racially inflamed case into something even more combustible, so they agreed, verbally, nothing written down, nothing filed with the court, to keep the darkest material away from the jury and the public alike. Then Wersky started reading from what had been kept out. Here's where it's worth slowing down, because there are really 2 versions of this case now sitting side by side. Version 1 is the case the jury actually decided. A boy under a tent, a shove, a knife, 1 stab wound, a self-defense claim the jury rejected. Version 2 is the case that's now spilling out in a courtroom a year later, and it complicates almost everyone involved. On Anthony's side, prosecutors say his phone showed what Wersky described as a documented pattern of fixation on guns, knives, and fighting. They pointed to a text sent the morning of the stabbing, hours before Metcalf died, in which Anthony wrote, "I'm low-key on the verge." They described another message in which, according to Wersky's characterization in court, Anthony fantasized about stabbing someone and licking the blood off the blade. And they said that on the morning of the killing, Anthony's then girlfriend went to school administrators and told them she and Anthony had broken up, that she was afraid of him, and, according to testimony, that he wouldn't take no for an answer. None of that reached the jury that convicted him. It's also worth being precise here. This is testimony and characterization from a hearing, not a finding of fact from a trial. The court has not ruled on what these messages actually mean or prove, and Anthony's team disputes the framing. On Metcalf's side, the defense laid out its own version of what got buried. According to testimony and court filings discussed at the hearing, Metcalf had a documented record of racist language and graffiti at school, including references to a well-known hate symbol and a Nazi-associated phrase, discovered by administrators. The defense also pointed to a 2023 incident in which Metcalf was accused of bullying a black classmate, and to a much earlier incident back in elementary school in 2018, in which Metcalf and his twin brother Hunter were accused of bullying and assaulting another student. Both Metcalf and Hunter reportedly had juvenile records tied to some of this history, records that, again, never reached the jury deciding whether Karmelo Anthony acted in self-defense against him. It's important to be careful with this material too. These are allegations and disciplinary records surfaced by the defense to support an argument about what Anthony may have reasonably perceived as a threat. They are not proof of what kind of person Austin Metcalf was as a whole, and a 17-year-old's disciplinary file, even a troubling one, doesn't answer the central legal question of what happened in the seconds under that tent. Records reviewed by attorneys reportedly show Metcalf and his brother describing some of their own past conduct to school administrators in blunt, minimizing terms, acknowledging some dumb stuff and some vandalism, language that undercuts any attempt to paint either narrative as simple. What all of this material does answer is a much simpler question. Why two sets of lawyers, worried about a case already on fire, decided the public and the jury were both better off not seeing any of it? One word. If you'd been sitting on that jury and you'd seen all of this before you voted, does your verdict change? Yes or no? Drop it in the comments. I'm reading them. Anthony's trial attorney, Mike Howard, took the stand himself during the hearing to explain how the agreement actually functioned in practice and how it fell apart at the worst possible moment. According to his testimony, the arrangement held through most of the trial. Then, on the final day of witness testimony, right before Anthony would have had to decide whether to testify in his own defense, prosecutors told the defense the deal was off. Their argument: the defense had already opened the door during opening statements by mentioning, almost in passing, that Anthony liked playing chess, a small, humanizing detail the prosecution treated as a violation of the agreement to keep character evidence out entirely. Once prosecutors declared everything back on the table, Howard has said Anthony was given roughly 10 minutes to decide whether to take the stand, knowing that if he did, the state could now introduce the very material, the texts, the girlfriend's statement, the juvenile program, that the defense had spent the whole trial trying to keep buried. Anthony chose not to testify. Howard has since described the arrangement, in blunt terms, as an old-school, off-the-record way of running a case that had no business deciding what a jury gets to hear in a matter this serious. That's turning point number 2, and it might be the one that matters most, legally. Karmelo Anthony never told his own story to the jury that convicted him, not because he didn't want to, according to his own attorney, but because a secret handshake deal collapsed at the worst possible moment and left him 10 minutes to make the biggest decision of his life. So where does that leave things? As of this hearing, the case has become as much about process as it is about the stabbing itself. Anthony's new team is arguing multiple, overlapping violations that the secret agreement itself deprived the jury of context it needed to fairly evaluate self-defense. That Anthony's right to testify was effectively coerced out of him by a last-minute reversal, and that the severely restricted public access to the trial, no cameras, no audio, a public gallery capped at 27 seats for a case with national attention, violated his right to a public trial in the first place. Prosecutors, for their part, have defended the original trial as fair, arguing that the agreement was a reasonable attempt to keep a volatile, racially charged case focused on the actual facts under that tent, rather than turning it into a referendum on two teenagers' worst moments. Both arguments are, in their own way, about the same underlying problem. What happens when the people running a courtroom start making judgment calls about what the public and the jury are capable of handling? And all of it is now sitting on retired Judge Michael Chitty's desk, with a legal clock that doesn't care how complicated the story got. Texas law gives him 75 days from sentencing to rule. That's Monday, August 24th. If he doesn't rule by then, the motion is automatically denied, no explanation required, and the door to a new trial closes by default rather than by decision. If he grants it, Karmelo Anthony's 35-year sentence is wiped off the board and the case goes back to square one, a new jury, and, this time, a much fuller record of what both boys' lives actually looked like before that morning. If he denies it, Anthony's team moves into a formal appeal. Transcripts, briefs, oral arguments, a process that typically takes months, not days, and gives a higher court, not just one judge, the final say on whether this conviction stands. It's worth understanding why this motion for new trial step exists at all. In Texas, it's usually the first and fastest chance a convicted defendant gets to argue that something went wrong at trial, heard by the same level of court that handled the original case rather than a full appellate panel. That's normally a steep uphill climb, because it typically means asking a trial judge to admit their own mistakes. What makes this version of the process unusual is that Anthony isn't asking Judge Roach to reconsider his own rulings. Roach is gone. He's asking an entirely different judge, hearing the case fresh, to weigh whether a secret, unwritten agreement between two sets of lawyers was serious enough to undermine the fairness of the whole proceeding. That's a genuinely open question, and it's part of why legal analysts following the hearing have been careful not to predict which way Chitty will rule. That uncertainty is the entire story right now. Grant the motion, and the 35-year sentence disappears. A new jury is seated, and this time that jury hears about the texts, the graffiti, the juvenile records, the girlfriend's warning, the whole file, not half of it. Deny it, or let the clock run out without a ruling, and Karmelo Anthony's conviction stands while a slower appellate process grinds forward, with no 75-day deadline forcing anyone's hand this time. While all of this plays out in a courtroom in McKinney, Karmelo Anthony himself has already been transferred into the custody of the Texas Department of Criminal Justice, assigned to the PAC unit near Navasota. He's serving time as a convicted murderer, while his lawyers argue, in a different building, that the conviction itself was built on a foundation neither he nor the public ever fully saw. That's not a contradiction the system resolves quickly. It's just where things sit right now. It's worth pausing here, because it's easy in a story with this many legal twists to lose the fact that a 17-year-old is dead, and that fact doesn't move no matter what a judge rules next week. Austin Metcalf's family has spent the past year and a half grieving in public, under a level of scrutiny most families never face, while strangers online turned their son into a symbol for arguments that had nothing to do with who he actually was. The disciplinary history that's now surfaced in court doesn't erase that grief, and it isn't offered here to render a verdict on Metcalf's character. It's offered because it's part of the record a jury should have had, one way or another, when they decided what happened to him and why. Both things can be true at once. That a 17-year-old's death is a tragedy regardless of what turns up in a school disciplinary file, and that the file itself was relevant to a self-defense case and shouldn't have been hidden by agreement between two sets of lawyers. And that's really the through line of this entire case, underneath the race politics and the social media noise and the 35-year sentence, A series of adults in positions of institutional authority, 2 teams of lawyers, and at least 1 judge, repeatedly deciding, on their own, what the public and the jury were and weren't allowed to know. The gentleman's agreement kept character evidence out of a murder trial without a single court filing or judicial ruling authorizing it. The seating and recording restrictions kept most of the public out of a trial with national attention based on security reasoning that was never fully tested in the open. And the trial judge himself, days after sentencing, went on television and offered his personal opinion on a case he might still have to rule on. A decision serious enough that another judge later found it created a reasonable appearance of bias. None of those 3 decisions were made by a jury. All 3 of them are now the reason a 35-year sentence is hanging by a legal thread with days left on the clock. This was a case decided by 12 people who were handed less than half the file, and the reason they were handed less than half the file wasn't an accident. It was a decision made quietly by the very people responsible for making sure the process was fair. So here's the reframed question, now that you have the fuller picture, and this one's not one word. I want your actual reasoning. Given everything that got hidden from that jury, on both sides, does Karmelo Anthony deserve a second trial, or should the verdict stand as it is? Tell me which, and tell me why, because this ruling is coming within days, and I want to know where you land before it does. By the time you're watching this, Judge Chitty may already have ruled. Texas law doesn't give him room to wait. Either Karmelo Anthony is heading back to a courtroom for a second trial, this time with a jury that gets to see the file both sides tried to keep closed, or his 35-year sentence stands, and the appeal moves to a slower, higher court with no deadline forcing anyone's hand. What won't change, no matter which way this goes, is the fact underneath all of it. A system that's supposed to run on transparency let 2 lawyers make a private call about what an entire jury was allowed to know. And it took a year, a recused judge, and a hard legal deadline to even get the truth of that agreement into public record. If you want to stay on this one as the ruling comes down and whatever comes after it, subscribe, because the fatal truth is going to keep tracking this case exactly the way it deserves, with the full file, not the version that fits in a headline.